I'd now like to talk to you about Clare's Law, which is the informal name for the Police Domestic Abuse Disclosure Scheme. The female in the picture there is Clare Wood, who was murdered by her ex-boyfriend George Appleton in 2009 in Salford, and his picture's there also for you to see. Appleton strangled and burned Clare and then killed himself several days after murdering Clare. Appleton had served 3 prison sentences before his relationship with Wood: 6 months for failure to comply with a restraining order, 2 years for harassment, and 6 years for holding a woman at knife point for over 12 hours. Following her death, Clare's family stated that she would not have entered into a relationship with Appleton had she known of his violent past, and so her family started a campaign. It was first implemented in 2014, and following a pilot with GMP and other forces, the policy structure was then implemented. DVDSs provide guidance to the police in exercising our common law powers to warn the public about a potential threat in the specific context of domestic abuse. The courts have held that the exercise of such powers by the police must conform to 3 criteria: the relevancy, the necessity, and proportionality. The scheme has 2 elements: the right to ask and the right to know. Under the scheme, any individual or relevant third party, for example a family member, can ask the police to check whether a current or ex-partner has a violent or abusive past. This is the right to ask. If records show that an individual may be at risk of domestic abuse from a partner, the police will consider disclosing the information. The right to know enables the police to make a disclosure on our own initiative if we receive information about a violent or abusive behaviour of a person that may impact on the safety of that person's current or ex-partner. This could be information arising from a criminal investigation or through third sector agency involvement or from another source of police intelligence. In terms of who's involved in the DVDS, we will have the applicant, and this is the person who will make that application. We will then have the person at risk. This is the person who potentially may be at risk of harm from that subject, and we will then have the subject themselves. Now, the applicant and the person at risk may be the same person, but the applicant may be the mother of somebody, a grandfather, a best friend, a school teacher, literally anybody. Stage 1, this will be our initial contact, and this can be through a variety of ways: by coming into the police station themselves, through dealing with another incident, through online, a police officer on the street, disclosing to a social worker, for example. There are numerous ways we might get that initial contact. Stage 2, we will then do initial checks once we've received the information. We will create a DAB and all details will be recorded on that DAB. Stage 3 will then involve a risk assessment. We will need to ascertain if there's any immediate risk to the applicant or the person at risk. And if there is, we will then take immediate action to safeguard those individuals involved. Stage 4 will then contain contact with the applicant. This needs to be no later than 10 days from the initial contact. We need to ensure that the request is genuine and not in any way malicious, and we need to obtain further details to further risk assess and then provide safety information and advice to safeguard the person at risk. It's also important that if the applicant is not the person in the potential relationship, that their understanding is they will not be disclosed the information and it would go direct to the person who's directly involved with that subject. Stage 5 involves that once all our stages have been completed and there are no immediate risks, we will then refer to the Vulnerability Detective Inspector on district, who will then review. If, having carried out our Stage 2 and Stage 3 risk assessment, if there is immediate risk to that person, then immediate action must be taken. In terms of the decision-making process, what follows are 3 principles that we follow. So we have our disclosure test. This will conclude that disclosure to the applicant is necessary. There's a pressing need for such disclosure, and that interfering with the rights of the subject to have information about his or her previous convictions kept confidential is necessary and proportionate for the prevention of crime. We have to make sure that disclosure is in accordance with the Data Protection Act. And we also then need to consider about informing the subject themselves of the disclosure. Sometimes the subject will already be aware and will have given permission for their new partner to make the request, but sometimes they don't know and are unaware that that process is in place. We will then have a concern or a no concern outcome. A concern will occur if the person at risk is at risk of harm from the subject based on a balanced profile, and this will include if there's any convictions related to domestic violence, if the subject is a serial perpetrator of domestic violence, or there is intelligence known about previous violent offending of the subject, and that can include cases that have not been proceeded, have been NFA'd by the Crown Prosecution Service, and any sort of behaviour towards previous partners, so this can include a pattern over coercive and control. If there is a concern of behaviour by the subject that's demonstrated towards the person at risk, this may include a pattern of behaviours that indicate the subject is a domestic violence perpetrator. If there's no concern, this will be when there's no convictions for any offences relating to domestic violence, there's no intelligence that indicates the subject's behaviour may cause harm to the person at risk, and there is insufficient intelligence or information to register a concern. Stage 6 is the final stage, and this is when we will make the disclosure. Now we have to do this verbally, it has to be face to face, and ideally it's done at the police station on the division where the victim lives. The person that's receiving the disclosure has to sign an undertaking that they will keep the information they're told confidential. Failure to do so can result in criminal proceedings being made against them if that information was then made public on social media, for example. We have to see identification to confirm that the applicant is the person receiving the information, and we will then provide safeguarding information to that person, because sometimes, despite what they are disclosed, some people will continue to remain in a relationship with the subject. If there is no information to disclose, it's very important that the applicant is told that that does not mean that there is no risk of harm.